All right, let's take you to this now. The Democratic Alliance has argued before the Electoral Court that it would be untenable for a person in public office to use their position to promote a political campaign. The party is challenging President Cyril Ramaphosa's 26 May 2024 address to the nation ahead of the 29 May 2024 national and provincial elections. According to the party, the address was an attempt by the president to leverage his position as the head of state to influence voters unduly and gain an electoral advantage for the ANC. Now, the DA further contends that the electoral laws prohibit this. As a result, the party is asking the Electoral Court to declare that the president's address violated sections of the Electoral Act, the Code of Conduct, and the Constitution. Now, the DA also wants the specialist court to direct Ramaphosa to pay a fine of 200,000 rand and that the voters cast for the ANC in the 2024 elections be reduced by 1%. Well, to help us unpack all of this is legal analyst Kevin Smith. He joins us now in studio to weigh in on this particular story. Kevin, thank you so much for your time. So let's just look at then what the applicant, in this case the DA, is calling for as what we've just said in our intro. It wants to hold both the candidate and, of course, that is President Cyril Ramaphosa and party accountable, the ANC. I mean, what merits then does the DA, go about proving that this is in fact or was in fact a breach of the Electoral Act and the Electoral Code of Conduct?
Right, so the DA is alleging quite a number of things, but the structure of the application, I think they actually did the application a bit of justice. Reason being is that they said that the president's speech, it mirrored his electoral campaign speech, which had just preceded his presidential speech. Now, they do specify that he doesn't use the same exact language and the same phraseology, but the claims he makes in terms of his administrative campaign as president and the successes of that campaign are the exact same claims that he made in an aspirational tone when he gave his campaigning speech. So what they're actually saying is that if you look at the phraseology used, especially when he talks about a democratic renewal, and we know that in the ANC's campaign, they had been speaking about them renewing the ANC and coming back to their glory days. It can be construed that he was in fact using the stage in order to forward the ANC's political campaign. But importantly, why this is an issue is because his presidential speech wasn't done in his personal capacity or as president of the ANC. It was done as president of the country. So he was fulfilling his public office in giving that speech. And that is why he's not allowed to campaign on behalf of the ANC in that stage.
Of course, the president's lawyers are denying that he violated or was in breach of any of the electoral acts. But in the main, what would you then say is the president's strategy at this point in time?
Look, I mean, nothing precludes the president from making the speech when he had made it. The issue that they might come when they do get to court is no one can particularly tell the president what should form the content of any of his speeches. So the content of this speech becomes much more important than the timing of when the speech was given. That's due to the fact that the DA claims that given that he gave the speech 4 days before the elections, it must be that it was done in order to influence voters to vote on behalf of the ANC. However, the president making use of that forum, nothing precludes him from doing so, nor is there any law that tells the president what should be in his speech in particular. So it's going to come down to the court's discretion if they feel that what he had spoken about and the way he addressed the nation, if that can be seen as political campaigning, or if he was just doing his job and fulfilling his office as the president.
Let's look at what the DA then wants, from this court. I mean, it wants the specialist court to direct Ramaphosa to pay this fine of 200,000 rands and that the votes cast for the ANC in the 2024 elections be reduced by 1%. I know that there's another ask, and I want you to let's sit for this one, for a moment in terms of the votes for the ANC in the 2024 elections be reduced by 1%. I mean, how do you go about doing that? Because one of the greatest arguments, by the DA is that they want to defend the Constitution. But on the one hand, I mean, the 1% of voters might say that it was a constitutional right to cast their vote whichever way they went. But how do you go about proving that?
Look, let me actually start with the third ask. And the third ask is that the DA wants the court to proclaim that the president in fact used his office and he abused that office and he took advantage of it. That's the one component. They want a proclamation on that. So it can be said that his speech on that day, he did it as a violation of his constitutional rights. Now, when we look at the 1% reduction that the DA is looking for, in my personal opinion, I think that's the weakest of their claims. The reason being is that in order for them to show that there was a 1% advantage gained by the ANC by virtue of the speech, they will have to bring substantial evidence to show that had it not been for the speech, they would have had 1% less of their voters. So in them structuring their papers, they don't necessarily make out how they come to 1% or how they've quantified that 1%. And the reason for that is because it's impossible for them to do so. I think in their papers themselves, they have admitted to the fact that it would be impossible for them to assess the advantage that the ANC gained by virtue of the president having made that speech. So the 1% is just them saying that we feel as though we need a 1% reduction. And that 1% reduction would be so that they can reassess the number of seats in the National Assembly, right? But I think the court won't be able to grant relief of that nature because they can't justify why 1% is necessary. Why isn't it 10%? Why isn't it 0.1%?
All right, Kevin, I mean, before we end our conversation, of course, it would be very interesting to know when likely the court is going to make its decision, because, I mean, the elections have come and gone. I would imagine there's no, sense of urgency in this particular, matter.
Correct.
But there are other areas of contention, like, for instance, before this case, of course, or at least the DA made its intention to go to court, there was no GNU. Now, the DA and the ANC are in partnership in this government of national unity. I would imagine there's another contract that has been, also made on that front with the other parties. But what does this all mean then? And also, when are we likely to see and hear from the courts again in terms of their decision?
Look, you've rightfully pointed out, the sense of urgency is now gone, because by the time that the court adjudicates on this issue, the elections will have passed. The GNU has been formed. We know what our cabinet looks like. So they wouldn't be giving a judgment a day later or 2 days later as they would if this was done on urgency. So I foresee that the court might give it within the next week after the matter has been properly heard. And as you can tell from the structure of the DA's papers, they didn't foresee something like this happening, and that's something I mean is the GNU itself. So the best thing that they can gain from an application of this nature is a reshuffling of seats, or them getting additional seats, or them now having more leverage within the GNU at a provincial level. Because at a national level, things are pretty much set in stone.
Absolutely.
But I think what they're looking for most is the proclamation that the president had in fact taken advantage of his office, and that would give them more political leverage, whether that be internally within the GNU or externally with their own constituents.